115-A. Special provisions relating to children to be brought into state for private placement adoption. 1. In the case of a child whose admission to the U.S. as an eligible orphan with non-quota immigrant status pursuant to the Federal Act is sought for the purpose of adoption in New York, the following requirements pre-adoption shall be observed. A. The adoptive parent or parents must present to a judge or surrogate having jurisdiction of adoption proceedings in the county of residence of such parents a verified written application containing the information set forth in subdivision 2 of this section in such form as the judge or surrogate may prescribe for an order of pre-adoption investigation to determine whether the adoption is in the best interest of the child. B. The adoptive parent or parents must appear for examination before the judge or surrogate of the court where the pre-adoption proceedings are instituted. C. The application must be accompanied by duly authenticated documentary evidence. C. The application must be accompanied by duly authenticated documentary evidence. 1. That the child is an alien under the age of 16, and 2. That he is an orphan because of the death or disappearance of both parents, abandonment or desertion by or separation or loss from both parents, or who has only one parent due to death, disappearance, abandonment, desertion, separation, or loss from the other parent, and that the remaining parent is incapable of providing the care for such orphan and has written irrevocably released him for emigration and adoption and has consented to propose adoption. So all three of those things. So if there's one parent that's living, they're incapable of providing care, in writing irrevocably released him, and consented to propose adoption. In all cases where orphan has no remaining parent under circumstances set forth above, documentary evidence must be presented that the person, public authority, or agency having lawful custody of the orphan at the time of making the application hereunder has in writing irrevocably released him for immigration and adoption and has consented to the proposed adoption. And 3, that the adoptive parent agreed to adopt and treat the child as their own. D. In addition thereto, such additional releases and consent as the court may, in its sound discretion, require. 2. The verified written application shall contain the following information. Here we have another list. 1. The names and places of residence of the adoptive parent or parents. 2. Whether they're of full age. 3. Whether they're married or unmarried. 4. If married, whether they're living together as husband and wife. 5. Name, date, and place of birth of the adoptive child as nearly as the same can be ascertained. 6. Religious faith of the parents. 7. Religious faith of the child and his parents. 8. The medical history of the child. 9. The occupation and approximate income of the adoptive parent or parents. 10. The name that he's going to be known by. 11. That no previous application has been made to any court or judge for the relief sought, or if so made, the disposition of it. And 12, a statement as to whether the child has been previously adopted. 13, the facts which establish that the child is an eligible orphan who would be entitled to enter the U.S. with non-quota immigrant status for the purpose of adoption in New York State, pursuant to the Federal Immigration and Nationality Act. 14, in such case, the circumstances whereby the names and addresses of the intermediaries, if any, through whom the adoptive parent or parents learned of the existence and the eligibility of the child, and the names and addresses of the person or persons, public authority, or duly constituted agency in the lands of the child's residence executing the written release of the child for emigration and adoption, and the consent to such adoption, the circumstances under which the release and consent were obtained, insofar as they had known to the parent or parents, the adoptive parent or parents there. 2-A. The written application is verified. It shall contain the following information: the heritage of the parents, their nationality, ethnic background, race, education, which shall be in the number of years completed by the parents at the time of the birth of the child, the general physical appearance of the parents at the time of birth of the child. It has a description here. Why would they need to know that? Health and medical history of the parents at the time of the birth of the adopted child. hereditary diseases, anything known, any drugs and medication taken during the pregnancy by the mother, and any other information which may be a factor in influencing the child's present or future health, talents, hobbies, and special interests of parents. Our documentary evidence, agreement, and consents, the judge or surrogate, upon finding that it complies with 15-A and that it appears that the proposed adoption may be in best interest of the child, judge or surrogate shall issue an order of pre-adoption investigation hereunder. The order of pre-adoption investigation. Okay, 3. Upon receiving the verified written application, required documentary evidence, agreements, and consent, the judge or surrogate, upon finding that the provisions of 15-A have been complied with and that it appears that the proposed adoption may be in best interest of the child, the judge or surrogate shall issue an order of pre-adoption investigation hereunder. The order of pre-adoption investigation shall require that the report of such investigation be made by a disinterested person who, in the opinion of judge or surrogate, is qualified by their training and experience or by an authorized agency specifically designated by him to examine into the statements set forth in the application. The investigator shall make a written report of his investigation into the truth and accuracy of the statements, into the validity of the documentary evidence submitted with the application, and he shall ascertain as fully as possible and incorporate into his report the various factors which may bear upon the determination, including but not limited to the following information. So again, this is now we are talking about the pre-adoption investigation, what the investigator has to put in his written report. We have a list of 7. 1. The marital status and family status and history of adopted parents. 2. Physical and mental health of adopted parents. 3. The property owned by and the income of the parents. D. The compensation paid or agreed upon with respect to the placement of the child for adoption. 5. Whether either adopted parent has ever been a respondent in any proceeding involving neglected, abandoned, or delinquent children. So including delinquent children. 6. The desirability of bringing the child into New York State for private placement adoption. 7. Any other facts relating the familial, social, religious, emotional, and financial circumstances of the adopted parents which may be relevant to a determination of suitability of the adoption. The written report of the pre-adoption investigation shall be submitted to judge or surrogate within 30 days. Again, pre-adoption investigation shall be submitted within 30 days after such investigation and report is directed to be made, unless, for good cause shown, the judge or surrogate grants a reasonable extension of the period. So again, the written report of the pre-adoption investigation shall be submitted to the judge or surrogate within 30 days after the same is directed to be made, unless for good cause shown, judge or surrogate shall grant a reasonable extension of such period. The report shall be filed with the judge or surrogate in any event before the court shall issue its pre-adoption certificate that it appears that the adoption is in the best interest of the child. So now we have 3 papers that they've talked about so far. There's an application, a verified application, that's made by the pre-adoptive parents. The next thing is the pre-adoptive investigation. That's done by the investigator or the agency. Now the third thing we have here is something called a pre-adoption certificate. On the return of the pre-adoption investigation order, the judge or surrogate shall examine the written report of the pre-adoption investigation and shall determine, on the basis of such a report and further proof as he deems necessary, whether to issue a pre-adoption certificate as provided for in this subdivision. If the court is satisfied adoption is in best interest of the child and that there has been compliance with all the requirements hereof, and is satisfied that the moral and temporal interests of the child will be promoted by the adoption, the judge or surrogate shall issue an original certificate under seal and 2 certified copies thereof, setting forth the fact that a pre-adoption investigation has been conducted and reciting the documents and the papers submitted therewith, and stating that in the opinion of the court, there is compliance with all applicable laws, and that it appears from such investigation that the moral and temporal interests of child will be promoted by proposed adoption. So now there's one original and two certified copies. Now what do we do with them? The original certificate shall be filed with the clerk of the court. One certified copy with the State Commissioner of Social Services, the State Commissioner of Social Services, and the adoptive parents receive the second certified copy. The fact that the child was born out of wedlock shall in no case appear in such certificate. The written report of the investigation, together with all other papers pertaining to the pre-adoption investigation and the original certificate, shall be kept by the court as a permanent record, and such papers must be sealed and withheld from inspection. No person shall be allowed access to such sealed records and original certificate and any index thereof, except upon order of the court in which the pre-adoption certificate was made, or an order of a justice of the Supreme Court. So that means the only people that can ever issue this is family judge, surrogate, or a Supreme Court justice. That's it. Period. Those three. No county court. No order for access and inspection shall be granted, except upon due notice to the adopted parents and on good cause shown. In like manner as a judge of general jurisdiction exercises such powers, the court in which the pre-adoption certificate was made may open, vacate, or set aside such certificate for fraud, newly discovered evidence, or other sufficient cause. Okay? 5. The private placement adoption of children who have been brought into the United States and the state for such purpose and have been placed with the adoptive parent or parents shall be effected after issuance of the pre-adoption certificate in the manner provided by this title, excepting that A, the petition shall also recite the pre-adoption proceedings, and B, the court may, in its discretion, for good cause shown, waive a subsequent investigation. In such case, the order of adoption shall recite the reason for such action. 6. In any case where there has been a failure to comply with the requirements of the section, if applicable, no order of adoption shall be made until 1 year after the court shall have received the petition to adopt. So in any case where there's a failure to comply, no order of adoption can be made until 1 year after the court received the petition to adopt. The court may shorten the waiting period for good cause shown, and in such case, the order of adoption shall recite the reasons for such action. 7. Provisions of the section shall not be applicable to the adoption of children placed out or to be placed out for adoption by an authorized agency as defined in 371 SSL. 8. Notwithstanding any provisional law to the contrary, where a child is placed with a couple or individual in New York State for the purpose of adoption, and where said adoption has theretofore been finalized in the country of birth outside the U.S., the couple or person may petition the court in their county of residence in New York State for the readoption of said child in accordance with provisions of this chapter, providing for adoptions originally commenced in the state. In any proceeding for readoption, proof of finalization of an adoption shall be prima facie evidence of the consent of those parties required to give consent to an adoption pursuant to 111 of this article.